Today's session is drafting of sales deed. And so before we jump on to sale deed, I would like you to know that this document or this session is not only going to help you understand the crux of the sale deed, but also the crux of other transfer documents. But before understanding the draft of the sales deed, understanding what is all agreement for sale all about, we have to understand that sales deed or agreement for sale forms which part of the law. So as lawyers, we should be very clear in our thoughts, our expressions, so that whatever facts we have of the client are noted down and reduced into writing in a very proper and simplified way. Conveyance is nothing but transportation, that is transfer of one property to another person. So if A owns a property, that property is getting transferred through conveyance to another person. And it transfers through what? It transfers through a document which is known as deed. So conveyance deed. So all such documents through which a property is getting transferred to one person to another person's name is known as conveyance deed. And sales deed or agreement for sale forms the part of this section of law, that is conveyance deeds. And the most important thing that we're going to learn is how to draft a sales deed. We need to understand what are the acts that we need to follow. Indian Contract Act is the most important while you draft any document. Indian Contract Act, Transfer of Property Act, Registration Act, and Indian Stamp Act, the State Stamp Acts. We have to follow the provisions of all these acts and then inculcate into our drafting. All right. So basically, these two documents we are going to majorly look at, and especially agreement for sale is what we are going to look at majorly. So these are the topics that we're going to discuss today. So as I said, that the agreement to transfer any property will always form the part of conveyance deed, agreement for sale, sales deed. We'll start with the stages first. So there are many stages. We have just shortened it to 5 stages. So once you understand what are the facts from your client, then you start jotting down the points to be included in the draft. So obviously, then you are involved in the negotiations with the client, with the buyer, seller, you are there in between. You understand the terms and conditions of the buyer, you understand the terms and conditions of the seller, what is the consideration involved in the sales deed, and then you come up to some conclusion, and then you start with a memorandum of understanding. MOU is just it's called a non-legal document. It is not binding on the parties at all. It is just on a plain piece of paper. So if you are giving some token amount, then you have to prepare one memorandum of understanding, which depends upon the parties. If there are very good relations, you prepare or you don't prepare. But as a lawyer, you should always tell your client to please prepare an MOU, so which will be very important for further transactions, further set of documents. So negotiations, memorandum of understanding is the second stage. Then comes a very important thing is the agreement for sale and sales deed. Agreement for sale and sales deed, they both are very different. Agreement for sale is a promise or it's a willingness of both the parties. One party is willing and promise sell the property, and the other party, who is the buyer, is giving the promise or is willing to buy the property from the seller. We're just going to concentrate on one aspect of it, and that is residential property. Our agreement for sale is just a promise. It's a promise to fulfill in future, as in it's a futuristic agreement. I am promising to pay 1 crore to so and so person in future. In future, you are promising to do something, and that promise you're giving it today. So agreement to sell involves the terms and conditions on which the sale and purchase shall be transacted. Consideration amount shall be paid. So it might happen that during the MOU, you have already decided the consideration amount. Let's say it is 1 crore. And you've already given, let's say, 10 lakhs. And then during the agreement for sale, you're drafting the agreement, and during the time of executing it, you're paying the 50%, including the MOU amount, that is the token amount. You are already paid 50 lakhs, and 50 lakhs is remaining. So in the agreement to sell, you will mention this exact point, that the total consideration amount for the said property is 1 crore, out of which 50 lakhs has already been paid through NEFT, RTGS, or through check, cash, whatever it is. And the remaining 50 lakhs shall be paid within 3 months from the execution of the date hereof. There's also one thing in transfer property which is called as part performance. So based on section 53A, part performance of contract, this is such a type of contract that you have already done partly. As in partly you have already paid, and partly you need to pay something in future. So on the basis of that, you prepare agreement for sale so that it remains as an evidence. And then rights and obligations, of course, are recorded in agreement for sale as well. Once some kind of amount is paid, you go to the sub-registrar's office, register the document, and wait till the time buyer pays the other half of the consideration amount. And once the buyer pays the other half of the consideration amount, then comes the time of executing a sales deed. So sales deed is nothing but the actual transfer of ownership rights. So once agreement for sale is entered, it is a promise to fulfill in future. The promise which has been fulfilled in future is now getting recorded in the sales deed, which says actual transfer of ownership. So here basically it says that the entire consideration amount is paid, and after the full and final settlement of the amount, the transfer is getting placed immediately, as in the entire right, title, interest of the seller is now getting transferred on actual basis on today's date to the buyer. So here the sales deed is the actual transfer of ownership which is happening in the present day. An agreement to sell is a futuristic transaction. So here in Maharashtra, the registration of agreement for sale is very important. Now you might ask that, is it necessary to register the sales deed as well? Well, 99.99% nobody registers a sales deed. It's just a piece of paper where both the parties agree upon terms and conditions that whatever the consideration amount was there, it was full and finally settled. And now the delivery and the possession of the property is now getting transferred to the buyer, which is written in the sales deed. So why it is not important to register a sales deed? Because you have already registered once both the parties along with witnesses have been present in the sub-registrar's office. They have already done the registration work. They have already shown the original documents, original chain of agreements, which we will discuss about later on, of course. And they have already paid the stamp duty for the entire consideration amount. So again, paying the stamp duty is not what law asks for. Government is only concerned about the payment of stamp duty. Once the stamp duty is paid on the transfer of property, that's it. Once the entire consideration amount is paid, you have to execute a sales deed. With or without registration, it's your choice. So now we understood that typically 5 stages of a sale transaction looks like, and what are the documents that we need to prepare. First one is the MOU, which is a non-binding, non-legal contract. It's just an understanding between two parties. Then we come for agreement for sale, then sales deed. We'll understand what agreement for sale should look like. These 4 parts are very, very important. This will always be there in any agreement. So first one is the preamble. Then comes the recitals, clauses, and signing and sealing it. Preamble is the title of the property. If my name is A, I have to be A. I can't put my name as AB. I have to be that sure that even the first name, second name, and the surname is exactly how it is there in your Aadhaar card or PAN card. So your identification proof will play a very important role in the preamble. First, the title of the agreement, then the abbreviations is very important. Date of execution is the date on which you are registering the document and not when you have drafted the document. Place of execution, of course, very important, and names and addresses of the party. This is how a preamble should look like. It is always advisable that you use the word vendor and buyer. You don't use the word vendor and vendee, because then you will get confused. You should always write either the opposite words, as in if you're using the seller, then use the word buyer. If you're using the word vendor, then use the word buyer. Now, how to choose the title? Of course, this is very important. You have to know the nature of the transaction. If I am only preparing the document for the middle stage of the transaction, let's say I'm preparing a document which consists of futuristic promise, then I can't term it as sales deed, because sale deed is something where there is actual ownership of the property which is getting transferred. But if it's an agreement for sale, if there's some part of consideration which is left to be paid, then you have to choose the title according to the intention of the party. Then comes the recital part. As I said, that are 4 parts. One is the preamble, which we have already finished. We come to the recital part, which is the most important part, because this is going to prove ownership of the seller and the genuineness of the seller. Whether the seller is correct or not, whether he is genuine or not, it is just going to be based on the recitals part. There's a property in Goregaon, and there are a lot of old buildings in Goregaon. If you see, there are buildings which are more than 30 years old, and there are many transactions which have taken place for the same property. A has bought from B, B has bought from C, C has bought from D. So there are 3 transactions here, A, B, C, D. So there might be 3 agreements in it between A and B, B and C, and now the new one will be C and D. So here D goes to C and says that I want to buy your property and I want to see the chain of documents in it. And C says, yes, I have purchased it from B. You can see it. So he provides a document which he has purchased from B, but B does not have that document which says that he has purchased from A. So here the chain of document is very important. You have to ask the client how old is the property and how many previous buyers were there for the same property. How many original owners were there for the property. It might happen that the property is ancestral. It might happen that A was the ancestor of B and he actually never purchased from A. It might happen that through a release deed, the property was transferred from A to B, then from B to C, there was actual sale transaction, and now the new transaction is getting created between C and D. So where is the release deed? Where is that registered release deed that you have to ask the client? Because if you don't have it, then you can't enter into a new transaction. So that you have to include in the recitals. Recitals is nothing but a story. If there is a flat, if there is a residential flat in Goregaon, there must be a story behind it. The story is what? The chain of agreement. Who was the first owner, second owner, third owner, and who is going to be the fourth owner. So now the recitals are of two types. One is in narrative recitals and one is introductory recitals. So in recitals also, there must be a chain of agreement that you should enter according to chronological order and not just in any manner. So narrative recitals is nothing but the story. A gave it to B, B gave it to C, C gave it to D. And now what is happening? Now C is giving it to D. So C is selling the property to D will be the introductory clause. And the narrative clause will be the history, the chain of agreements. So these are the recitals that you should write in the agreement. Why I am putting so much pressure on the recitals? Because first, it will show that the seller has clear marketable title towards the flat. You have to enter these words in the draft that the seller is having a marketable title towards the flat. The flat is without any encumbrance. Without any encumbrance, as in there is no loan on it. It is free in the market to be sold. There is no other person who is going to claim on the properties. So recitals play a very important role as because they form a part of corroborative evidence also. If there is any breach of contract, breach of sale agreement, and then the dispute goes into the court, then of course the recitals can be used as a corroborative evidence. They are not the evidence because obviously you should have original documents to support it. But if you don't have original documents to support it, if you just have the information, it can be termed as a corroborative evidence in the court of law, subject to the judgment or subject to the order of the court. So clauses again follow the terms and conditions of the agreement for sale. So clauses again are of two types: operative clauses and boilerplate clauses. Operative clauses should include operative words. It should include the words such as the buyer has got clear and marketable title, sufficiently entitled to sell the flat legally to the buyer. So that all you need to include in it. You should also include the words such as the seller is in full use, occupation, and in exclusive possession of the flat. Exclusive possession as in only that person is having the possession of the premises and not some other XYZ person. So exclusive means that only you have, and you're going to give their exclusive possession to the buyer. That means only buyer in the next stage of the transaction is going to have the possession of the flat. Operative clauses are the general clauses. That's as in you will enter the facts of the present case, which will change from every case to case. As in, if there is a consideration amount of 1 crore, I mean, there will be a different consideration amount for other properties, not the same. So it is going to change. Rights and obligations of the parties are going to change. What the buyer is going to do shall change. When the buyer is going to pay the money is going to be different in every case. So here the transaction, rights and obligations, conditions precedent. Conditions precedent as in, okay, so there are a list of documents that you need to procure. Let's say if you are entering into a sale transaction, there are a list of documents that you need to procure, either from the society or which you already have. You have to show it to the buyer. So when a sale transaction is getting executed, the major role is played by the society, because you need to get a permission from the society that whether the seller can sell the flat to the buyer. So here in agreement for sale, it is always written that there are conditions precedent. Before the sale transaction takes place, the seller has to obtain an NOC, that is non-objection certificate, from the society, saying that the society has no objection if the seller sells this flat to some buyer. There are a lot many documents that you need to procure: PR card, a commencement certificate, occupation certificate, OCCC, property card, municipal taxation bill, the original chain of agreements. These are lists of the documents that you need to procure. So these are the conditions precedent that you need to follow. What are the representation and warranties? If there is any discrepancy in the flat, if there is any leakage in the flat, or if there is any defect, major defect in the flat, that has to be shown to the buyer by the seller. If there is any ongoing loan on the same flat, that has to be shown to the buyer. Representations and warranties should be clearly written, that you actually have clear and marketable title to the for the flat, and that you are indemnifying, that you have to write the word that here the seller is indemnifying the buyer, that whatever loss, claim, or damages which arise in future because of the mistake of the seller shall indemnify. That is, he will pay off for all the damages, claims, or losses which the buyer has suffered from. Then there are other clauses such as handing over of the possession property. So you have to again mention the word that peaceful and vacant possession. Peaceful and vacant possession shall be handed over to the buyer from the seller after the full and final consideration of the entire amount. So peaceful and vacant possession, these two words are operative words that you should include in the draft. Then there are default and dispute resolution clauses. It might happen that even after registering the entire agreement for sale, you pay the entire stamp duty on the entire consideration amount. It might happen that the buyer defaults or the seller says that I don't want to sell the flat anymore. So now what happens is that you are breaching the terms of the contract. A legally binding contract, you have breached the terms. So here you can specifically enforce the contract. You can either go to the court. If there is an arbitration clause which is mentioned, you follow the arbitration. If not, then you can go and file a criminal case or civil case, whatever is suggested. You can do that. So default and dispute resolution clauses are very important, because still the agreement for sale is not full and final settlement of the transaction. That is important. Force majeure clause is nothing but how do you say khuda na khasta kuch ho gaya to, act of God. So if there is an under construction building going on, the building was supposed to be 22 storied, but the construction stopped at 15 floors only because some earthquake happened. If the construction is stopped in midway, or the transaction is stopped in midway because of the fault of some third party, there's no fault of the first or the second party. There is some act of God which happened through which the transaction was cancelled. So in this case, what will be the damages that need to be paid off by both the parties? That all is written. So these are the force majeure clauses. Then comes the signing and sealing part. Of course, as I said, before you go for registration, you should be very thorough with your draft. Everything should be proper. Not even a single mistake should be there in the draft, because again, you can't call the party and then waste your hour and two in the registration office. Your draft should be very perfect, along with all the annexure of the documents. There will be a signature page. Signature page is very important. In that page, you give the exact same name which you have entered on the title page, the preamble page. That the names of the witnesses should also be mentioned along with the addresses. There should be space to stick photos, and there should be space to write the PAN card numbers and Aadhaar card numbers during the registration time.
Okay, Mohini,
Yes.
on behalf of the plea team and the participants, we extend a hearty gratitude for conducting such a wonderful webinar. Thank you so much for providing the practical insights. Thank you.
Thank you so much for having me here.